Hello, and thank you for joining me for another episode of You Would Think. So, we are on day 17, and today was a short day. The chaplain from Brigman's hospital, I believe, spoke with Lindsay, and she goes over, the conversations and that they had together. Really, I mean that was it. That was the whole day, and the judge had spoke to the jury and said that it was going to be a short day due to some unforeseen circumstances, which I think has to maybe do with the scheduling of Dr. Spinelli, which we've heard about, that we're going to hear from them, but we haven't yet. So that's what I think. Today was interesting because, this was the first time, at least that I saw, that there were tons of Lindsay Clancy's supporters outside the courthouse. They were all wearing pink, and they were in support of Lindsay. And in the courtroom as well, you could see a lot of people, especially some in the front, and they were wearing pink. So it was clear they were there to support Lindsay. It's the first time we've seen that. And I was kind of taken aback that day 17, we get supporters. So we're going to listen to a little bit of the chaplain, and I'll show you a little bit of the supporters outside the courthouse as well. Okay, so we'll also full disclosure, I am not an attorney. I do not have a law degree. My degree is in crime scene and forensics. Trials and true crime is more of a hobby for me. So I thought of creating a channel where I can discuss them with you and get your perspective and, just be able to talk about them. It's interesting to me. So with that, let's get into it. All right. Well, we'll start with the supporters outside the courthouse. We'll take a little look at that so you can see. And again, to my knowledge, this is the first day that this went on. So.
Hey guys, that's live in the action. That's what's happening
Sweating. I was like, I did everything done I can yesterday. I'm getting my phone. Making this. So, I did. I was like, I got all the wedding stuff done yesterday.
So you can see, quite a few people. Then we hear from the chaplain. The chaplain, she testifies that she had met with Lindsay about 200 times. She talks about the male voices and the male voice that Lindsay heard that day, which before we had been told she'd never heard those voices before the incident or after. And so far, it's staying that way, because when she talks about the voices in this context, it's still just talking about that day, that she heard the voices. So, could listen to a little bit of that.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed. She was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday, the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two. Okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday, the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe." I replied theologically to Lindsay, and I said, "Lindsay, your children are safe. They're safe in heaven with God." And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice, and the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things,
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
And do you know when that was?
That was roughly late February, perhaps around the 23rd.
And did you continue to see Lindsay at Spalding Rehab?
I did.
Do you know when she left Spalding Rehab?
In the late March, early April time frame, perhaps.
Okay. Now, Brigham and Women's Hospital in Spalding Spalding Rehab, are under the same umbrella of hospitals. Is that right?
They are. So Brigham and Women's Hospital and Spalding Rehab are under the Mass General Brigham complex. So for me to visit Lindsay and Spalding, I was still within the same hospital complex, and her psychiatrist at Spalding, as well as the chaplains, advised me to continue.
You can't say what anybody told me.
Oh, sorry.
So when she was discharged from Spalding Rehab, where did she go?
She went to Tewksbury State Hospital.
And fair to say that that would be back around February. It's been a little more than 3 years, or 3.5 years.
Yes.
Is that correct? Now, when you saw her in Spalding Rehab and in Brigham and Women's, you were acting in the course of your job. Is that right?
That's correct.
So you're being compensated, you're getting your paycheck and that type of thing, right?
Yes.
So now the prosecution is going to have their opportunity. And I think it was interesting that the very first thing that they went to was the police presence that the chaplain had mentioned. They say, well, there was a search warrant going on, right? So they were collecting items they needed from Lindsay. So, of course, there were a bunch of police because that was something that was going on. And the chaplain said she wasn't aware. So they kind of dispelled, the reason that all of those officers were there. And then, of course, they start talking about, the voice that she says that she heard, and the fact that she met with her 200 times. She alluded that she took meticulous notes. However, not once in her notes did she write down anything to do with the voices, which I did think was a little odd because, as you'll see, the prosecutor reads excerpts from the notes about other comments Lindsay made to her, but nothing about the voices. I mean, don't you think that would be something pretty important to be putting in your notes? I think so. But I thought that was a little strange. So you can watch a little bit of that.
How many times have you seen Lindsay at Tewksbury Hospital?
Perhaps 200 times.
I saw Lindsay in direct examination, and you said that there were a lot of police officers in the area, correct?
Correct.
But you mentioned that some of them were security personnel from the hospital, correct?
Correct.
And you're aware that the security personnel for the hospital don't work for the state police, the Duxbury Police, or the Plymouth County DA's office, correct?
Correct.
So they're separate and apart from law enforcement, correct?
Yes.
And then are you also aware that on January 25th, 2023, there was a search warrant being executed to collect evidence from the defendant and from the belongings that she had at the hospital?
No, I was not aware of that.
Were you aware that that collection of the search warrant required state police and personnel from the crime lab to be present for the collection of evidence?
I was not aware of that.
Were you aware that following that, at any given time, there were only 2 officers, either Duxbury Police, State Police, or Plymouth County Sheriffs, at her room, the defendant's room, at any given time?
I do recall that.
And they were stationed outside of her room, correct, in the hallway?
Yes.
So that the only time you saw this large amount of officers present was on the 25th, when there were security from the hospital and search warrants being executed, correct?
Perhaps.
Okay. Now, you mentioned that on January 31st, 2023, you spoke to the defendant and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You you wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events. Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And speaking of Spalding, you continued to visit her at Spalding, correct?
Yes.
In those conversations with her at Spalding, did she tell you that how in those first weeks at Spalding, that part of her physical therapy, she was working out with a yellow exercise band? No?
I don't recall her telling me that.
Did she tell you that during that time at Spalding, she reached out to a social worker there and asked for help filling out SSDI paperwork to get an income?
That would be beyond the scope of our conversation.
She didn't tell you those things?
No.
Thank you.
So, counsel has asked you about her filling out a form for SSDI. Were you aware of what expenses her family and were incurring as a result of her physical incapacity, paralysis, and being in the hospital?
From my experience with thousands of patients, I had a very clear idea of the enormous expense.
There's a difference between, as the district attorney very appropriately referred to, that your comments were about her thoughts and her appearance and her feelings. Is that correct?
Correct.
There's a difference, however, between privileged communications with a chaplain and observations of a person's feelings and thoughts, correct?
Correct.
Tell the jury what effect privileged communication has when someone talks to you personally as a chaplain.
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted. I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, "I feel uplifted," or is that your
was my
observation?
perception of Lindsay. It was not her words.
Thank you.
Thank you.
Como?
You said you're not allowed to put the defendant's words in your medical records. Is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
Then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes.
Thank you.
I use my best judgment.
Okay.
So yeah, the note thing was kind of weird. But all being said, you know, this chaplain, she seemed credible. You know, she was very poised, you know, on the stand. And then the judge took the opportunity to go over just a few, like, trying to hammer out a few of the jury instructions with the attorneys. And one of the things, defense wanted that. They wanted something called involuntary intoxication from all the medication she was taking. The prosecution, you know, disagreed and said that, you know, at the time, she only had like 1 or 2 of those medications in her system. She wasn't overly medicated at the time. The toxicology shows she only had a few prescriptions at that time in her system. So, you know, the involuntary intoxication thing, they don't think should be part of the jury instructions. And then they just argued a little bit more about just some more administrative type things, what types of charges they were trying to allow the jury to consider, and a few other things of that nature regarding the jury instructions.
I'll hear from the defendant.
So for individual instructions, we have listed opinion testimony, prior inconsistent and prior consistent statements, redactions. I don't think there are too many, but there were some on the death certificates, stipulations, and consciousness of guilt instruction. In terms of what we're looking for for the charges, we'd be looking for an instruction on first and second, with the theories of first being both deliberate premeditation and extreme atrocity and cruelty. In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given, because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription, 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from. And I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children. And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
Let me ask you this. I'm going to ask the defendant as well, because I did read through those. And I was trying to find the definition of intoxication as it applies in the homicide instructions. Most of the cases that I was able to find so far is the dealing with the OUI statute, Chapter 90, and trying to find the real definition in regards to that. Is it the Commonwealth's position that the intoxication is beyond what was the considered effect of the drugs? Because if you know what I'm saying, so if she takes if a defendant, I don't mean to personalize it, if a defendant takes prescription drugs and it does create some effect, would that be considered intoxicated for the instruction?
I don't believe so. I think in the instructions it talks about having being intoxicated to the point where it affects your state of mind or ability to control yourself. I think intoxication, especially where there's not a specific definition given in the homicide instructions, I think you go to the general definition of intoxication, which would not just be taking medication as prescribed, but it would be over taking medication or combining with alcohol or other drugs. It's similar to the instructions in OUIs, operating under the influence of alcohol or drugs. I think you would have to go to that definition or to the general definition of intoxication if it's not specifically defined in the instructions. And I think the general definition of intoxication is taking some type of substance, either alcohol, drugs, medication, in excess and to the point where it's affecting your ability to think and to act and to control your behavior.
All right. All right. Anything? So I've got opinion, prior, consistent, prior, inconsistent, redaction, stipulations, consciousness of guilt, first, second, extreme atrocity, deliberate premeditation, and the criminal responsibilities without the subparagraph or the paragraph regarding intoxication.
Correct.
Okay. All right. Mr. Reddington?
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge to the jury, based upon the evidence that's been presented, whether or not it's what we would argue is the over prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be. All of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence, repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos. She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams. And then subsequent to that, when there's additional SSRIs prescribed, to suggest that there's no basis to give the jury the instruction, they may determine based on the evidence that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention. But I would at some point ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct, with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second. But I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice aforethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
All right. Yeah, counsel.
Thank you. The Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death. So there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital. And she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital. And then she was without those medications and they're out of her system for 3 weeks. And she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean. It's what happened on the day of the incident. It's similar if it's an OUI. It doesn't matter if you were drunk in November. It matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right.
So that was really the conclusion of day 17. I appreciate very much you guys joining me, and make sure to put your questions and comments in the comment section, and to like and subscribe so I can bring you more content. And thank you so much again for joining me for another episode of You Would Think, and I hope you have a great day.